Journalists are given certain rights guaranteed by the First Amendment to the U.S. Constitution. The First Amendment is the first of 10 amendments to the Constitution. The first 10 amendments are called the Bill of Rights. Among other rights, the First Amendment provides the rights to free speech and free press. It states, Congress shall make no law respecting an establishment of a religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. This constitutional right to freedom of the press protects journalists and the media against censorship. Censorship is the prevention or attempted prevention of printing or broadcasting materials that are considered by some people to be objectionable. The First Amendment guarantees journalists the right to express themselves in publication, but no more so than other citizens. All U.S. citizens are protected under the First Amendment. There are a couple of notable court cases, Supreme Court cases, that do influence student journalism. The first is the case of Tinker versus Des Moines, which was a 1969 case that went all the way to the Supreme Court. The Tinker case developed because high school students in Des Moines, Iowa had been wearing black armbands to protest American involvement in the Vietnam War. The school administration ordered them to stop because it considered the action disruptive and a violation of school regulation. The students refused and were suspended. The case eventually reached the Supreme Court. The court decided against the administration, ruling that neither students nor teachers, quote, shed their constitutional rights to the freedom of speech or expression at the schoolhouse gate, end quote. The opinion suggested that censorship might be allowable only if student expression, either written or verbal, materially disrupted classwork, or if it involved, quote, substantial disorder or invasion of the rights of others, end quote. Since the Tinker decision, numerous court cases have clarified the rights of school publication in regard to the freedom of the press. The January 1988 decision in the Hazelwood versus Kuhlmeyer case upheld the right of public high school administrators at Hazelwood East High School in Missouri to censor stories concerning teen pregnancy and the effects of divorce on children, written by members of the Hazelwood East Spectrum staff. The 5-3 vote reversed the decision of the U.S. Court of Appeals for the Eighth Circuit in St. Louis. The court had upheld the rights of the students to print the articles. The U.S. Supreme Court, however, said that the rights of public school students are not necessarily the same of the adults in other settings. Thus, the students were not entitled to First Amendment protection of freedom of speech. The court said that when a school's decision to censor is, quote, reasonably related to legitimate teaching concerns, end quote, it is permissible. In other words, if administrators can present a reasonable justification for censorship, that censorship will be allowed. Basically, what this boils down to for you as a student journalist is that these cases allow school authorities to exert some control under specific circumstances on newspapers that are not deemed public forums for student expression. So having that administrative control means that principals or other school officials could demand to see articles before they are published. They could censor articles they don't think are appropriate. Policies are usually in place that designate student publications as public forums and give student editors control of content and make censoring by school authorities more difficult.